Once again, this is my Telegram channel, people. Any doubts or queries that you have, please ask it over here. You can also send in your answers of the PYQs. In the last class, we have just wound up with Parliament. And Parliament, we saw about its sessions, sittings, privileges. These were the topics that we dealt with. Today's class, we are basically going to start off with Judiciary and we are going to see what are its associated problems. When it comes to Indian judiciary, let me tell you, there are 2-3 main areas what we talk under judiciary. One, it is basically about judicial activism, judicial overreach, judicial adventurism. This is one topic which is constantly there in the news always. The other topic is with regard to how the problems associated with the judiciary in terms of backlog of cases and then with regard to its appointments. Indian judiciary is the only judiciary in the world where judiciary appoints itself. No other democratic country in the world is there, or otherwise also you will never find another country as an example where judiciary alone appoints itself. If you look at every other appointments that are made in our country, there is some sense of transparency. Like we know, okay, how does the Prime Minister form? We know what is the criteria. When we talk about Chief Election Commissioner or CAG, etc., we know generally it will be a senior IAS officer. We have an idea, okay, this is the person, this is how it will be appointed. But what is the basis for judiciary to appoint its own judges? Nobody knows. What is the criteria? Who sets the criteria? What are the do's and don'ts here? There is no clarity whatsoever. And this has been a bone of contention always. So these are the two topics that we are going to see here. One more thing what you have to understand here is these two topics, if not here, definitely you will get it as a question in your GS paper 2. Like I have told you, when you take public administration as an optional, there are a lot of advantages, especially for your GS paper 2. And your paper 2 of PubAd is nothing but a magnified version of GS paper 2. Good afternoon, Satish. Good afternoon, Suganya. So let us take it forward. Again, this is just for your information because it is just history, which we have already seen under British administration. So let us see. Indian judicial system is largely a British legacy. 1773 Regulating Act established a Supreme Court in Calcutta. 1861 Act established 3 high courts, Bombay, Madras and Calcutta. Government of India Act 1935 established a federal court which was renamed as Supreme Court of India on 28 January 1950. Part 5, Article 124 to 147 deals about the Supreme Court's structure, composition, powers and authorities. Part 6, Article 214 to 231 deals about the High Court's structure, composition, powers and authorities. Article 232 to 237 talks about the subordinate courts. Just a general introduction only. Just you can use these points maybe while you are writing the answer. That's all. Clear? Taking it further forward. Appointment of judges. Article 124. The judges of the Supreme Court are appointed by the President. The Chief Justice of India is appointed by the President after consultation with such judges of the Supreme Court and High Courts as he deems necessary. The Chief Justice of India is appointed after consulting with a plurality of judges. Plurality of judges when we say discussing with more than one judge at the Supreme Court level, also at the High Court level. The other judges are appointed by the President after consultation with the CJI and such other judges of the Supreme Court and the High Court as he deems necessary. The consultation with Chief Justice is obligatory in the case of appointment of a judge other than Chief Justice. It simply means if the President is going to appoint any other judge, Other than Chief Justice of India, consultation with CJI is compulsory, who will also consult with other judges while making appointments. Clear, people? So while appointing other judges to Supreme Court or High Court, consultation with CJI is essential. Fine. This is the general structure what we are having here today. But what is the history behind it? How did the current system come into picture? That is what we need to understand. Again, understand one thing. Nobody is going to ask you this history also. Chances are very less. Maybe in GS paper 2, you may get a question. But here, directly in paper 2, public administration, very less. So let us understand the history here. From 1952 to 1973, the senior most judge of Supreme Court was to be appointed as the Chief Justice of India. Whoever is the oldest, appoint them as Chief Justice. This was the practice, not that it is written down anywhere. It is not mentioned in the Constitution. It is not mentioned anywhere. This was the practice. But this was violated in 1973 and 1977 when A.N. Ray and M.U. Baig were appointed as Chief Justice of India, superseding senior judges. That is, people who are junior, they got appointed. Good afternoon, Abhinav. They got appointed as what? Chief Justice of India. So imagine your junior is still there as one of the judges in Supreme Court. You are thinking, now only I am the senior most here, I will become the Chief Justice. Suddenly, out of the blue, your junior becomes the Chief Justice of India. In Constitution, Article 124 and Article 217 states the provision about appointment of judges in Supreme Court and High Court. Okay. Now, there was a dispute here. What is the dispute? Article 124 or Article 217, if you actually read the content of the article, it talks about consulting with judges. So this consultation, that is, when you are going to appoint the Chief Justice of India or the Chief Justice of a High Court, you need to consult with judges. How many judge? One? More than one? No clarity. So, the Supreme Court has given different interpretations of the word consultation in the very famous the judge's case. Let us see what is the interpretation. In the first judge's case, 1982, the court held that consultation does not mean concurrence and it only implies exchange of views. That means government, while appointing the Chief Justice or other judges, I can consult, but I need not agree with whatever names they are suggesting or whatever viewpoints they are telling. We are just exchanging views. So it is just that consultation is just a formality. That is what the first judge's case ruled. 1982. Just a formality it is. Don't take it so seriously. Supreme Court changed its stance in the second judge's case. The court reversed its earlier ruling and changed the meaning of the word consultation to concurrence. The executive has to accept the views given by the judiciary. Means, I am the president. I want to appoint the judges. President means obviously president is not doing it independently. President ke piche kaun hai? Council of Ministers headed by the Prime Minister. So, I am coming there. I am asking them. Asking them? Give me the suggestions. They are giving me suggestions. I have to agree with it now. Not just mere consultation. Whatever names that are suggested by judiciary, I have to agree with it. The second judge's case gave birth to the collegium system. Why? Because here the Supreme Court again made it very clear that consultation means not just one judge but plurality of judges. And that is how this whole collegium came in. Collegium simply means a college. I'm telling it just for your easy understanding. That is, more than one party is involved there. So that is how consulting with multiple judges became a norm. In the third judge's case, 1998, the court opined that the consultation process to be adopted by the Chief Justice of India requires consultation of plurality of judges. They made it again more clear. So in the second judge's case, they made it clear for president. Dekho, this is how you should do. You should consult with multiple judges. In the third judge's case, they made it clear for the Chief Justice of India, consultation means you have to consult with more than one judge here, bringing clarity to Chief Justice of India's role. So in both the cases, now clarity has been brought in, and basically that idea has been brought in properly that more than one judge should be consulted before making any appointment. Taking it further forward, NJAC. So till here, this is the thing. Now we will see what is National Judicial Appointments Commission. This was an idea that was flouted earlier by the UPA government tenure, but it was struck down completely. We will see what it is. This is otherwise also known as the fourth judge's case. Let's see. 99 Constitution Amendment Act 2014 provided for a plural body for the matters of appointment and transfer of the judges to replace the collegium system. It was a 6-member body which had CJI and 2 senior-most judges of Supreme Court, Union Law Minister, 2 eminent personality. That means till the third judge's case, only who were involved there? Judges. Because executive has to agree to the judges. So only the judges were deciding things. In the NJAC, they brought in 2 changes there. One was the fact that you had direct presence of a minister, that is somebody from the executive. 2 eminent personality means somebody from neither from the executive nor from the judiciary, that is generally from the society. However, the Supreme Court upheld the collegium system and struck down the NJAC as unconstitutional on the grounds that the involvement of political executive in judicial appointment was against the principles of basic structure, that is the independence of judiciary. Supreme Court basically told no, executive cannot be part of this. Because separation of executive and judiciary is part of the basic structure of the constitution. So you cannot involve the law minister there. So NJAC itself is unconstitutional. With this single ruling, indirectly what they gave? Indirectly they gave almost a constitutional-like status to the collegium system. That is, collegium system you cannot touch. Because that is what it is. Judiciary is involved, executive is involved means it breaks the basic structure. So whatever structure we are having currently, that is the correct one, which is collegium. They have not told it directly, but indirectly they have done that. Indirectly, they gave a prominent status to the collegium system. It is also known as the fourth judge's case and is being criticized as it indirectly constitutionalized the collegium system. This is what we are currently following. Getting the point here, people? World over, even if you look at British judiciary, American judiciary, everywhere you can see executive, the parliament or the legislature, prominent personalities, all are involved there. Because it is such an important post, right? In our country, definitely we can say one thing, from High Court upwards to Supreme Court, we have no clue, no idea how are these judges getting appointed. Who is appointing them? How are they getting appointed? How is it that a certain judges, their juniors, their family members are only getting appointed to the top posts? This I am not telling. This data was revealed inside the parliament by the MP John Brittas, which was also appreciated by the then Vice President Venkaiah Naidu. Getting the point here. Taking it further forward. All India Judicial Services. Any doubts so far, people? All India Judicial Services. Why it is required? The service will give an opportunity for induction of suitably qualified fresh legal talent selected through a proper All India merit selection system. Something very similar to our civil services. Something very similar to that. If such a service comes up, it would help create a pool of talented people who could later become a part of the higher judiciary, that is the 25 high courts and the Supreme Court. Huge vacancy of judges and recruitment delay is there. Widening gap between the number of judges and cases. You can please Google it and find out what is the latest data. That is why I have not added it here, because every year that data keeps on changing. So what is the vacancy of judges, etc. You can Google it. It is easy. Vacancy of judges in High Court, vacancy of judges in Supreme Court. If you put it up, India also you put it up, you will get the number. Please add the number there. In next 30 to 40 years, the number of cases is expected to rise by 15 to 20 crore, which will require 80,000 judges. Getting the point here? In 25 high courts, there are approximately 1,000 plus judges. Former CJI Ranjan Gogoi raised concern over the pressure on the judicial system. Lower courts, more than 3 crore cases are pending. High courts, more than 0.5 crore. Supreme Court, more than 80,000. AIJS was first proposed in 1958 by the Law Commission of India. 42nd Constitutional Amendment 1976 provided for an All India Judicial Services. Law Commission in its first 11th and 116th 1986 report recommended for the creation of All India Judicial Service. Everywhere they are telling this. Create a service just like IAS, IPS, create an All India Judicial Service. That means ask UPSC to conduct an exam much similar to the lines of civil services, and then recruit them. Whoever has a background in law, completed their bachelor's in law, let them be qualified enough to attempt for that exam, and let us recruit them in different parts of the country. This is the suggestion. Niti Aayog in its report Strategy for New India at 75 also supported the idea of All India Judicial Services for making appointments in lower judiciary. If created, it will fill some 5,000 vacancies at the district and subordinate judiciary. There is a very good chance that this may come in the future. Reason is very simple. Like I told you, pendency or backlog of cases, it is only going to increase. And there is a gross shortage of judges. So the only way the government can fasten the whole process is what? Literally start doing the recruitment. Basically, Supreme Court told what? Executive should not be involved in the appointment of judges. Fine. But executive can conduct an exam and hire judges to the lower court. Recruit judges to the lower court. That is possible. AIJS can bring objectivity in the selection process and uniformity across the country. Definitely true. Because right now, we have no idea what is happening when it comes to judicial appointments. Who is appointing this? What is the criteria? We have no clue at all. Clear? It can bring wider representation from the disadvantaged sections of the society. No doubts about it. When we talk about minorities, OBCs, SCs, STs, these categories are very poorly represented currently in Indian judiciary. In fact, one of the criticism against the current setup of Indian judiciary is that general category is actually very high. When you look at the judges of High Court and Supreme Court, from general category it is very high. From these communities, it is actually very low. On top of it, general category is very high, one thing. Another thing observed is, women judges are also very less. So not just that it is creating caste discrimination or community discrimination, there is also gender discrimination. Current setup of judiciary. Out of the 650 judges appointed across various high courts over the past 6 years, as many as 75.7%, 492 individuals hailed from the general category. A mere 3.54%, 23 individuals were from the SC category. 1.54%, 10 individuals were from the ST category. 11.7%, that is 76 individuals were from the OBC category, while 5.54%, 36 individuals were from minority communities. Like I told you, this is the data. The answer also disclosed that the representation of women judges in high court stood at 14.1%, accounting for 111 women judges out of the 719 working judges. The maximum number of women judges in Punjab and Haryana High Court is 15, followed by the Madras High Court with 12 judges and Bombay High Court with 11 judges. In Supreme Court, there are 3 women judges, accounting for a meager representation of 8.82% of the current strength. Got the picture here, people? This is the reason why we are demanding AIJS, All India Judicial Service. Underrepresentation, number 1. Number 2, huge pendency of cases. To solve it, because justice delayed is justice denied. Now, one set of argument we saw. What about the other set? Why we should not go for AIJS, or what are the worries or fears against All India Judicial Service? देखते हैं. States are reluctant as they will lose their power of appointment and administer the lower judiciary. First issue is that states are not so happy. Currently, in all the state governments, if you see, lower judicial judges are appointed by the state government. So once that goes into the hands of the center or the union, they lose their control. States won't be happy about it. Second, language barriers and customs are also cited as hindrance. That is, how can a person of North India can serve efficiently work in South India? Is there any merit in this argument? See, for example, let us say now Satish gets appointed to Punjab as an IAS officer. Goes without saying, in his training period, he will have to learn Punjabi. That's how it is. Correct. Labasana training, that foundational course training, they'll be teaching. One chapter will be, or one session will be there for language, so that he's taught Punjabi. Same thing can be done with judges also. So that is not a very strong argument. But yes, one more thing is there. A localite will be having a better awareness of the culture and the crimes that are taking place within that state, compared to somebody who comes from another place or another state. Getting the point here? So yes, there are going to be a lot of hiccups. But at the same time, a person who is coming from outside the state, because he is not aware about the local culture, tradition, etc., they will only take a decision based on what? Complete merit, complete objectivity. We can expect rational decisions to come from outsiders rather than people of the same state. A person from other state may find it difficult to hold the proceedings in other states, and it will affect the quality of justice. Centralization of recruitment process will have a negative impact on state recruiting agencies. Everything is done by the center means state recruiting agencies, state PSC, etc. They will feel, then why are we here? It's true. To an extent, it will affect. Taking it further forward, the argument that recruitment through UPSC itself leads to efficiency is also criticized. That is, if UPSC recruits everything will be pakka, perfect, guaranteed. If that is the case, all the IAS and IPS officers in this country should be fantastic people. We will never hear about any ghotala, corruption, crime. Nothing we will hear. Getting the picture here. If UPSC was such a powerful body, only recruiting the best in the country, how is it that IAS, IPS officers are ending up in corruption and ending up in other crimes? So that merit itself is not there. Only if at all India level the exam is conducted, only then everything will become correct. That we cannot agree with. The issue of local language and customs are major constraints which deserve serious consideration before crafting the AIJS. Space for promotion will be curtailed for those state officers who are already in service if recruitment is made through AIJS. This is something which I have told you already. That is, currently what happens in any state. SP post is vacant, let us say. There is a DYSP. and he is from state service. And there is a ASP, who is an IPS officer. Given a chance, there is a greater tendency for this ASP to be given the promotion. If he has completed his training, everything, probation period, everything is khatam, means ASP will get the promotion there. Generally, that is how it is. So, many a times what happens is, state service officers will feel a little dejected. Oh, it will go only to the IPS officers. They know it. Very rare it will be. Rare means how I will tell you, if the DYSP is a very super senior, etc. And then there is this quota system also is there. Quota system means for this many state service officers who gets promotion, this many IPS officers from the union level should get promotion. Like that, it has to be balanced out. This is the criteria there. So in such a scenario, if you actually see, some sense of balance is there. So based on that quota system, they do this. Same thing you can do for AIJS also, right? That is, you have your normal magistrate. Normal magistrate is there, who is from state, and you have your AIJS magistrate. So, what principle you are using currently now for promoting ASP compared to vis-a-vis the DYSP or deputy collector and assistant collector, how you are doing the promotion, do the same thing. Getting the point here? The same thing can be followed. Then AIJS will only do a little to that what is exactly required. It is just a tip of the iceberg, as judicial reform is much needed in India. Poor judicial infrastructure and low remuneration is not addressed by the AIJS. How many people do you meet on the road who will tell you, I want to become a lawyer, I want to become a district magistrate? Very rare. It is very, very rare, because the system itself, when you look at an advocates, etc., especially, until and unless they have passed out from National Law University, Bangalore, or National University of Advanced Legal Studies, NUALS, nobody pays them any attention or nobody gives them any respect. Or if you are from a very like Khandani, you are a lawyer family, great grandfather onwards, everybody are lawyers. Then you will have some respect. Otherwise, nobody cares for the lawyers or the magistrates also. That is the reality. Plus, if you actually visit most of these courts, it is not so squeaky clean or very good infrastructure. Nothing will be there. In fact, many of the buildings, if you actually see, if you sneeze hard, that building will collapse. So, basic level things has to be ensured first before we talk about conducting exam, etc. That is ensuring 24/7 electricity, basic internet connection, video conferencing, video trial. All of that has to be ensured first before we actually talk about creating one more layer of exam. Getting the point here? Judicial review, judicial overreach, judicial activism. So very recently, the 3 new laws, criminal laws that have been passed also, that is also in the right direction, I must say. Clear? That is also in the right direction. Why? Because in the new criminal laws, digital evidence can be submitted as an evidence now. That is, it is accepted as a form of evidence. And there is a provision, clear provision is there for conducting trials online. Clear. So some reforms are happening, judicial reforms are happening, reforms with regard to the laws have also happened. Clear. Taking it further forward, judicial review, judicial overreach, and judicial activism. Any doubts here, people, before we move on to the next topic? In Indian parliamentary system, doctrine of legislative competence is guiding principle. The parliament has to work within the limits of the constitution, which naturally allows judicial review. In India, constitution is paramount and supreme. Judicial review is not explicitly mentioned in the constitution, but it is implicit under Article 13. It simply means judiciary can declare a law null and void if it is not in accordance to the provisions of the Constitution. Article 13, Clause 2, the state shall not make any law which takes away or abridges the rights conferred by this Part 3, that is fundamental rights, and any law made in contravention of this clause shall, to the extent of the contravention, be void. So the idea behind judicial review is simple. Legislature passes some law, electoral bond scheme. Judiciary looks at it. What nonsense is this? Strike it down. It is unconstitutional. Go. That is the purpose. To ensure that the parliament does not pass any such law which will interfere with the fundamental rights. That is the idea. Let us take it forward. Shankari Prasad versus Union of India 1951 and Sajjan Singh versus Rajasthan State case 1954, the Supreme Court had said that Parliament can amend any part of the Constitution, including Part 3. Including Part 3 means fundamental rights. However, in 1967, Golaknath versus Punjab State case, the Supreme Court reversed its position. That means, no, you cannot amend anything and everything. Parliament came up with 24th Amendment 1971, which says Parliament can amend any part or all provisions of the Constitution. Again, 24th Amendment. Parliament also didn't leave. They were like, if that is the case, we will make an amendment now, according to which we can amend any part of the Constitution. Any part. Court also didn't leave. 1973 Keshavananda Bharati verdict established the concept of basic structure. That is, what the court told is correct. You can amend. You are free to amend also. Because ultimately Parliament is made up of what? Elected representatives. You can amend. As long as you don't tamper with the basic structure of the Constitution. What is the basic structure? Like I've told you earlier, it has not been defined anywhere in the Constitution. It is purely a judicial invention. And Supreme Court also has never clearly defined what constitutes the basic structure. Our idea about the basic structure comes from various judicial rulings. Taking it further forward, not only any law or an amendment of fundamental rights, but any amendment to the Constitution or any law can be challenged if it's violating the Constitution and can be declared null and void. Judicial activism. First thing you have to understand is, sir, many students ask me, sir, what is the difference between judicial activism, judicial adventurism, judicial overreach? Let me tell you, it is just a matter of perspective. Actually, all the three are one and the same. We cannot say what is what clearly. But yes, in certain cases, if you ask me, is it activism or overreach? On case-by-case basis, we can decide. Let us see. Judicial activism is the use of judicial power to articulate and enforce what is beneficial for society, whereas judicial overreach is when the judiciary starts interfering with the proper functioning of the legislative and executive, thereby encroaching upon the legislature and executive's domain. Activism means judiciary is interfering in the activity of legislature and executive, but it is beneficial to society. They are thinking something, that is, they're thinking ahead and seeing that, okay, people are in trouble, let us get this clarity here. They are involving. The other one is literally where what the executive or legislature is supposed to do, Supreme Court is coming and interfering and doing in it. Let us see this in detail. It simply means more active and intense role played by the judiciary. It means that judiciary not only will look into the legal or constitutional aspect of the matter, but also the natural and human side of the case is very important. A judge is generally considered more willing to decide constitutional issues and to invalidate legislative or executive actions. The alleged ineffectiveness of the legislature and executive in India has given rise to the judicial review. Due process of law is the basis of judicial activism. Due process of law means Has the law been followed? On what basis have you taken this action? And whenever executive or legislature fails to do their duty, that is where judiciary will step in. As the citizens become more aware, assertive, demanding, and informed, they will demand more and more. Public interest litigation has helped the cause of judicial activism as locus standi need not be explained. In India, it was started by Justice P.N. Bhagwati and Krishna Iyer. Public interest litigation, filing of PIL. Now, what is PIL? Say, for example, there is a huge pollution issue in Delhi. So, I can file a PIL. On the behalf of the public, I am filing a PIL directly in Supreme Court. I'm filing a petition there and telling that, please look into this matter. Supreme Court takes it and says, yes, we are going to do it. Okay. Now, let us say, okay, I am facing some personal issue with my neighbor or something. Suganya, looking at my trouble, my issue with my neighbor, Suganya goes and files a PIL in the court. Suganya goes and files a PIL in the court on my behalf, talking about my problem there. In the first case, Supreme Court will not ask, what is your locus standi? But in the second case, Supreme Court can ask, what is your locus standi here? What is the difference? In the first case, if you see, I filed a PIL in Supreme Court. Why? For what reason? Because of the pollution in Delhi, which is genuinely a public concern it is. So, PIL stands, they need not ask me, what is your connection to the case? That locus standi simply means, what is your connection to the case? That court is not going to ask me because it's a public problem. But in this particular case, when Suganya filed a PIL on my behalf, I am having a problem with my neighbor, she goes and files a PIL there, means court will ask Suganya, what is your connection to the case? Are you related to the neighbor or is she related to me? If she cannot establish a relationship, court will throw it off. Getting the point here? This is another issue that is there. Public interest litigation, in saying that this is in public interest, so many PILs are filed in the court, be it at High Court, be it at Supreme Court. And most of these petitions are in what nature? Frivolous, unwanted, no merit is there, nothing is there. Supreme Court also goes mad actually reading all these frivolous petitions. Clear? By 1980s and 90s, the legislature and executive becomes less effective, which provided the space to the third organ of the government, which is judiciary. Why 80s and 90s? Because this was the time period of coalition era. And you know it, prime ministers were coming and going in. The legislature and the executive, basically, politicians lost their glory and credible image. People have faith and trust in judiciary, so it started to play a more active role. 1978 Maneka Gandhi case, Supreme Court established the due process of law. So due process of law simply means what? Follow the process properly. Don't tamper with it. Maneka Gandhi case was a landmark in many ways because it literally put an end to the manmani. That is, okay, I am an IAS officer, I can do whatever I want. Oh, I am a cop, I can do whatever I want. It literally put a stop to it. According to the law, what powers you have, only that much you can use. Nothing more, nothing less. The concept of public interest litigation and an informed citizenry eventually gave rise to judicial activism. Collegium system, again, can be highlighted as what? An example of judicial activism only, because nowhere it is mentioned in the constitution. Parliament also never passed a proper law on it. Finally, who did it? First judge's case, second judge's case, third judge's case. Collegium system today has a implicit constitutional status. That is, no government is going to be successful in tampering with it. Then, playing national anthem inside theatres before the movie starts. Judiciary only made that decision, not the government of India. Compulsorily, we have to play the national anthem before putting the movie. Some people may say, so what? We are all Indians. What is wrong in playing the national anthem? Let us say somebody is going to watch an adult movie, a pornographic movie, or maybe a too violent movie. What is the whole point of playing a national anthem before that? There is a time and place for everything. Somebody who goes to the theater, they are going for entertainment. They are not going for patriotism. Ban on liquor in along national highways. Selling liquor along national highways should be banned. Court order. Now, national highway, if you ban liquor, means obviously people generally, truck drivers, etc., for them going to a nearby dhaba, eat well, sleep, drink well, sleep there for the night, wake up fresh in the morning, then start their journey again. That is part of their culture. What does Supreme Court to do in it? Establishing the due process of law, the basic structure of the constitution. All these are again highlighted as examples of what? Judicial activism. Because establishing due process of law, like I told you, it was an outcome of the Maneka Gandhi case. The basic structure of the constitution was an outcome of the Keshavananda Bharati case. All of this, if you see, generally these decisions, that is banning liquor along highways, all of that, these decisions are supposed to be taken by the government, not by the judiciary. But judiciary stepped in and took the decision. These are few examples of judicial activism. As you can clearly see, in each of this, somewhere or the other, there is a public concern involved. No doubt. Taking it further forward, judicial overreach. With increased complexity, more and more demands and inadequacy of law at times has certainly increased judicial activism. More and more suo moto cognizance and technological advancement, the judiciary, as alleged, is infringing the spheres of the legislature and the executive, so it is named as judicial overreach. Separation of power is disturbed because of this judicial overreach. When judiciary intervenes in the spheres of others, that is the legislature and the executive, it is termed as judicial overreach. Same thing only I have kept on repeating. That means judiciary, executive, legislature. So this is how normal it is supposed to be, where some element of mutual cooperation is there between the judiciary, legislature and the executive. Slight overlap of functions, that is okay. But sometimes what we are seeing is literally judiciary entering into executive's work, that is framing laws or implementing laws, taking decisions, telling the government, do this, do that, or making a law, what the job of the legislature. Let us see. Judicial overreach is only when the legislature and executive underreach. There is a very thin line between judicial activism and judicial overreach. Judiciary stepping in policy matters, especially related to fiscal policy, political affairs, internal proceedings of the legislature, etc., can be categorized as judicial overreach. That means, very recently, judiciary made a few comments orally with regard to freebies. That is, you people are having enough money for giving freebies. Just when we are asking for our salary, you don't have money. Question asked by the judiciary. Getting the point here. Now, court could have simply told, nothing doing. We are doing our work here. Increase the salary and give. Correct. But instead they went on to pass a comment on a governmental decision to give freebies. Court is asking, oh, just when we ask salary, you people don't have money. But to give out freebies, for that you have enough money with you. Got the point here? It is very hard to categorize what is judicial review, what is judicial activism, and what is judicial overreach. Under Article 13, Clause 2, it is a Supreme Court which has to ensure the rule of law. Banning on Deepavali firecrackers citing pollution. Best example of judicial overreach. Why? To ban something, it is not the court's job, first of all. It is the government's job. First thing. Second thing, court said, okay, Diwali, we will ban it. And we will ban it even in rest of the country. In other cities also, we were thinking of banning it. That is what court told. Very nice. Only problem is, what about the people of Shivagashi district in Tamil Nadu? Shivagashi district in Tamil Nadu is one such place where agriculture will not work there because that soil contains high level of sulfur content. So agriculture will not work there. What is the only other option then? Utilize it for making firecrackers. There's a huge firecracker industry thriving in Tamil Nadu. Women, especially women, they are dependent on it. Getting the point here. Banning the use of private vehicles after 10 or 15 years. The next point. Supreme Court, ban the vehicle. Anything old, diesel old vehicles and all, we are not going to allow here. Fine. After 10 years, when somebody has to sell their vehicle, Supreme Court will give the money to buy the new vehicle. Getting the point here. See, all of us are not Ambanis or Adanis. We will buy probably one car in our life and we will use it for 15, 20 years. Sometimes, if the car survives for that many long years, we will pass it on to our children also. Correct? I know people, I have friends again who have literally inherited their parents' Wagoner, etc. and they are using it still. Because the idea is, anyway it is running. As long as it is running, let it run. Finally, when we cannot use it anymore, that time we will sell it. Because they are not going to get much money out of it. So they are thinking like that. Now, these friends of mine, again, one of them is from Delhi again. So after this 10-year thing got over, he cannot use it there anymore. What his father did, do one thing, you take it to Bangalore, you use it there. He's still using the car here. Getting the picture. Invalidating the National Judicial Appointments Commission Act. That is the next thing that they have done. NJAC, they did not accept it. Ban of liquor sale at retail outlets that are within 500 meters of any national or state highway. Cancellation of telecom licenses in 2G cases. Judicial legislation in Vishaga's case regarding the prevention of sexual harassment of women in the workplace. Of all the points, this is the best thing that the judiciary did. Literally, they put up guidelines as to what constitutes sexual harassment at workplace. Supreme Court gave the decision. These constitutes sexual harassment. Getting the point here. And that is how you have POSH training today, POSH. This verdict given by Supreme Court has been responsible for creation of POSH. That is prevention of sexual harassment at workplace. Everybody is given training in this, private field or public field. Clear? The Supreme Court of India setting up of the Lodha panel to probe the allegations of corruption and match fixing in cricket and betting scandals in Indian cricket seen as interference, not warranting the involvement of the apex court. IPL betting is there, etc., etc. is there. Supreme Court immediately said, okay, constitute Lodha panel, start investigating it. Where is the public interest in it? First of all, it is IPL. People of the same team playing against each other. Private players are only involved. Even if there is an allegation of corruption also, let the government appoint a panel. Why are you interfering in it? Interference in the educational policies of the government. Islamic Academy of Education and others versus State of Karnataka. Sealing of unauthorized commercial operations in Delhi. In enforcing contracts indicator, India achieved. Okay. So, all this again directly interfering with the educational policies of the Karnataka government and unauthorized commercial operations, whatever were happening in Delhi, sealed them Who is telling? Supreme Court. Whose job it is to seal if unauthorized commercial operations are there? Government. Why is Supreme Court interfering in it? So this blatant interference by the judiciary in anything small, big, in almost every matter, so much so that we don't know कि किसमें interfere करेगा, किसमें नहीं. We ourselves don't know. So what has this led to? In enforcing contracts indicator, India achieved 163rd position in the Doing Business Report 2020, an improvement of 23 positions from the 186th rank in the Doing Business Report 2015. Means judiciary involving everywhere. It is generally anything you want to do in India. Finally, where you will end up? You will end up in the court. Because enforcing contracts means what? Contract has been signed. Now, put it into action. उस contract को निभाओ. Validate it by what? Do what you have promised in the contract. If it is not done, go to the court. But these days, thankfully, what is happening is that is slowly coming down. And that has somewhere improved the ease of doing business ranking of India. Clear, people? Any further doubts here? Any questions? Recommendations of second ARC, just for information only. National Judicial Council should be constituted in line with universally accepted principles where the appointment of members of the judiciary should be by a collegium having representation of executive, legislature and judiciary. The council should have the following composition: the vice president as the chairperson of the council, the prime minister, the speaker of the Lok Sabha, the law minister, the leader of the opposition in the Lok Sabha, the leader of opposition in the Rajya Sabha. In matters relating to the appointment and oversight of the High Court judges, the Council will also include the following members: the Chief Minister of the concerned state, the Chief Justice of the concerned High Court. The National Judicial Council should be authorized to lay down the code of conduct for judges, including the subordinate judiciary. The National Judicial Council should be entrusted with the task of recommending appointments of Supreme Court and High Court judges. Again, just recommendation only. That is, appoint a National Judicial Council to appoint the judges to the High Court and the Supreme Court, which will have representation from the legislature, executive and judiciary. Way forward, you can suggest this. Clear? Just that is why I am reading it off, because first of all, Supreme Court is not going to listen to it. Goes without saying. Supreme Court is never going to approve it, because first thing Supreme Court will see is what? Oh, Chief Minister is there. Oh, no. Executive cannot be involved in judicial appointments. It is against the basic structure. Like that, they will keep on telling. So this also is just an idea. You can write it in your answer. That's it. Taking it further forward, it should also be entrusted the task of oversight of the judges and should be empowered to inquire into alleged misconduct and impose minor penalties. It can also recommend approval of a judge if so warranted. Based on the recommendations of the NJC, President should have the powers to remove a Supreme Court or High Court judge. Article 124 of the Constitution may be amended to provide for the NJC. A similar change will have to be made to Article 217. Also, since the Council is to have the authority to oversee and discipline judges, further changes will need to be made to Article 217, Clause 4. All these are, I would tell you, dreams. Dreams of the ARC. That is all that I can tell you. Because any which way in this last 10 years also, at least in this last 10 years, easily you would have never read about this in any paper also. Getting the point here, because even to do this in the parliament, you will have to move the bill. It will have to get ratified by the state legislatures also. Why? Because you are going to make changes to the High Court appointment, judges appointment. So a special majority with ratification by half of the state legislature is required. by some medical miracle that gets done also, Supreme Court is never going to entertain it. Goes without saying. Clear? So that is why I'm just reading through. Don't break your head over this, because just for your information and to fill way forward of your answer. Clear? That is the only purpose of this section. A judge of the Supreme Court should be designated as the Judicial Values Commissioner. He or she should be assigned the task of enforcing the code of conduct. Similar arrangement should also be made in the High Court. Previous year questions. There has been an opinion that the ethos of Indian judicial system continues to be colonial, suggest measures for raising the level of judicial excellence for achieving speedy justice. So, why is it colonial? I'm only talking about the body here. Intro, you can write, what is it? The whole thing. Article 122, this is the Supreme Court is there, High Court is there, etc., etc. That you can write. Why is it colonial? Because there is a certain secrecy even today with regard to appointment of judges. General category dominating every other category. Men dominating the women. Those data you will give. Suggesting measures for this thing. You can start from where? National Judicial Appointments Commission, National Judicial Commission, then All India Judicial Services. Done. Answer is over. What will you give here? Paper 1 theory. Too colonial because even today this is having a centralized structure. Supreme Court, High Court, Lower Court. Top down it is. Just like our classical theory. Functioning of judiciary, when you generally see, it is top down only. Not that the lower court is telling to the Supreme Court, listen, do this properly. That is not at all possible. Getting the picture here? Then NJAC, NJC, AIJS, these are all clear indicators of what? System 4. Participative management, metrics organization, involving with, informal groups, all that you can put it up over here. Got the picture, people? This is the way to write. Next question. Judicial overreach to a large extent is a consequence of ineffective executive. 15 marks 2018. So wherever executive is not doing a good job. Case in point being, executive did not do a good job with regard to air pollution in Delhi. Why? Because constant conflict between the Legislative Assembly of Delhi and Union government. What was the result finally? Ban on firecrackers. Then IPL scam. Inaction from central government. What was the final result? Supreme Court appointed Lodha panel. Where there is conflict, Supreme Court will show domination. Where there is inaction, Supreme Court will show theory Y. Like that you can write for the other ones also. Getting the picture here? So each and every time, whenever an inaction is there or government is showing theory X, judiciary will intervene. That's it. Give a few more examples if you want. Finish it off. Getting the point here. This is the way to write. So once you write it in this fashion, 2-3 examples you give. Briefly elaborate what is theory X, what is domination, what is theory Y, etc. Easily marks also will come. Getting the point, people? Moving on. Cabinet Secretariat. It's 3:30. Do one thing. Take a 15-minute break, people. Then we'll get back. Cabinet Secretariat. The Cabinet Secretariat is responsible for administration of the Government of India Rules 1961. The Government of India Rules 1961. Allocation of business. The other one is transaction of business. Don't get shocked with all this. Point is very simple. Now we know that there is what we call as Council of Ministers, correct? Within this Council of Ministers, you have what is called as Cabinet Ministers. Cabinet, when we generally say, it is a super decision making body within the government. Cabinet approved, when they say, what it means is the most important ministers along with the prime minister have taken a decision. And once that undergoes, whatever be it, whichever bill be it, Waqf bill, electoral bond scheme, whatever it is, once it is approved by the cabinet, from there it goes into the parliament. From there, again, it is discussed as a normal bill, etc. This is the general idea. Because for everything, I cannot call the Council of Ministers. Because Council of Ministers will have Ministers of State. Minister of State means Minister of State simply means not that it is a minister for a state as such. No. The idea here is that this person is basically having a lesser responsibility than the main portfolio. So it will be a huge number. Council of Ministers means a huge number. I cannot call every time 100 or 120 odd people, sit and discuss with them everything. It is practically not possible. So when I want to take critically important decisions, I may inform Minister of Finance, Minister of Home Affairs, Minister of Defense, Minister of Education, and again, those ministries with which is related to that subject. I'll contact those ministries. Say, for example, National Education Policy. Definitely, I will call the Education Minister there. Or I'm going to talk about the 3 farm bills. Definitely, I will call the Agricultural Minister there. So this is the manner in which generally decisions are taken. So because cabinet has such an important decision with regard to which bill should go to the parliament, what should be discussed in the parliament, those provisions, those details, etc., you need a super powerful body again to assist the cabinet. Because again, see, MPs don't have quality means you cannot expect much quality from your ministers also. Number one, many of them when they read a bill, they won't understand what is it. So you need somebody to assist them. Plus on top of it, ministers are basically, they are burdened already with what? Politics. They don't get time. So to help them in framing a bill, to help them in assisting, to provide them with information, to collect data, to coordinate between ministries, everything, you need one body. And that body is what? That body is really our cabinet secretariat. Clear, people? This is the idea. So let us see this now in detail. It facilitates smooth transaction of business in ministries or departments of the union government. That means it helps in coordinating. It provides secretarial assistance to the union cabinet and cabinet committees. Secretarial, just like a secretary, assisting them. It assists in decision making in government by ensuring inter-ministerial coordination. The cabinet secretariat ensures that the president, the vice president, and ministers are kept informed of the major activities of all ministries or departments. So it's linked with everything. So if you generally look at it, you have what and all there? President, vice president, prime minister, ministers, other departments. Linking all of this is our super body called cabinet secretariat. Clear, people? Development. The Executive Council of the Governor General was responsible for all government functions before independence. Later, the works were divided among the members of the council due to growing complexities. Portfolio system was introduced during Lord Canning's tenure. Secretariat of the Executive Council was headed by the private secretary to the Viceroy. Under the interim government, the Council for Governor General was redesignated as the Cabinet Secretariat. That means what was initially the Executive Council of the Governor General, that got reformed, and finally it became what? Cabinet Secretariat. Executive Council's purpose was only one thing, to help the Governor General. Today, that same Executive Council is the Cabinet Secretariat to help the Cabinet Ministers. Economic Committee of the Cabinet was shifted to Cabinet Secretariat in 1950. In 1954, the Organization and Methods Division, one second, before we head any further, this is all FYI. In 1954, the Organization and Methods Division was established under the Cabinet Secretariat. 57, the Defense Committee of the Cabinet was constituted under Cabinet Secretariat. 61, Department of Statistics, the Intelligence Wing. 65, 66, the Bureau of Public Enterprises was brought under the Cabinet Secretariat. June 1970, three departments, namely Department of Electronics, Department of Scientific and Industrial Research, and Department of Personnel, again brought under Cabinet Secretariat. The Directorate of Public Grievances was set up in the Cabinet Secretariat in March 1988. 1997 National Authority Chemical Weapons Convention, again Cabinet Secretariat. Direct Benefit Transfer Mission was created initially under Planning Commission but was transferred to Cabinet Secretariat in 2015. The office of the Principal Scientific Advisor to the Government of India has been placed administratively under the Cabinet Secretariat in August 2018. Organization politically headed by the Prime Minister, administratively by the Cabinet Secretary. Again, most of the time it will be a senior IAS officer. Cabinet Secretariat is organized in three wings: civil, military, intelligence. Civil wing is the primary one, which provides secretarial assistance to the cabinet and the cabinet committees. Functions: the business allocated to Cabinet Secretariat under the Government of India Rules 1961 includes secretarial assistance to the cabinet and cabinet committees, the rules of business, how to conduct the overall administration between the ministries. Sometimes some internal conflicts, etc. will be there. Cabinet will get involved and sort it out immediately. Allocation and disposal of government business, support to cabinet committees, promotion of interministerial coordination. The Cabinet Secretariat is responsible for the administration of the Government of India, Transaction of Business Rule 61, and the Government of India Business Allocation of Business Rule 61. It works in facilitating smooth transaction of business in ministries or departments of the Government of India. Ensure that there is no hurdle, there is no ego clash, that everything moves smoothly. Support to cabinet committees, secretarial assistance to the cabinet and its committees, convening of the meetings of the cabinet and its committees on the orders of the Prime Minister, preparation and circulation of the agenda. That means Prime Minister is the one again who will call these meetings and they will decide what is to be discussed, which bill to be taken, what clauses. Okay, everybody okay with it? Okay, let us put it across. That is the idea. Circulation of papers related to the cases on the agenda, preparation of records of discussions, circulation of the record of discussions after obtaining the approval of the Prime Minister, monitoring implementation of decisions taken by the cabinet and its committees. Number 3, promotion of interministerial coordination. In case of interministerial cooperation, the ministries and departments often seek assistance of the Cabinet Secretariat. Committees of secretaries are very instrumental in this regard. Committees of secretaries means each ministry has their own secretaries. So, cabinet, obviously, cabinet secretariat cannot directly ask the minister, hey, you go and work with the other minister. That they cannot do. What is the issue there? So, the senior IAS officer, the cabinet secretary will call the other secretaries and ask, what is the issue here? What is the problem? Which law here? What clause? They will sit together. They will sort it out. They will clear it. Because ultimately, issue is never between ministries. Issue is always with the laws. Ministers will not have ABCD clue about it. IAS officers will be able to understand what is the issue there. They will sit together, they will sort it out, they'll go tell the minister, now that problem is sorted. The minister will ask, done. Okay, sign. Finished. Getting the point here. This is how this works. Committees are constituted for discussing specific matters and proposals emanating from various secretaries to the government meetings are held under the chairmanship of the cabinet secretary. These committees have been able to break bottlenecks or secure mutually supporting interministerial action. The Cabinet Secretariat is seen as a useful mechanism by the departments for promoting interministerial coordination. So you can clearly see there is nothing much here. Cabinet Secretariat, paper 1, if I had to link, it is just nothing but a coordinating or an integrating body. That's it. They don't take any independent decisions by themselves. Whatever it is all left to the agenda set by the Prime Minister of the country. So if you have a single party, if the Prime Minister is very strong, automatically Cabinet Secretary or Cabinet Secretariat will not have much role. Why? See, Cabinet Secretariat means there is a discussion, right, between ministers, everybody, what to do, what not to do, all that. But if we are talking about a very strong Prime Minister, means Prime Minister, if he wants to take a decision, he will directly take it through Prime Minister's office. Why he has to sit through the cabinet? Getting the point here. This is the next discussion where we are going to take it to. A monthly report is also sent by ministries or departments to the Cabinet Secretariat providing details on a wider range of issues such as important policy matters, compliance of Committee of Secretaries' decisions, sanction for prosecution pending for more than 3 months, departure from transaction of business rules, implementation of e-governance, etc. What is its significance? The role and function of the cabinet in a parliamentary democracy is unparalleled. It is the supreme policy-making institution in India. It is true, like I told you, anything that the government wants to do, Prime Minister, whatever it is, they'll put it across the cabinet first. Once the discussion, everything is done, then they take a decision, then they send it to her for its next action. Say, for example, 7th Pay Commission. Cabinet gave its approval, yeah, set it up. Now they are going to set up the commission. They will review the overall inflation, etc. And they will increase the, central government servants' salary. Cabinet Secretariat is the secretariat to the cabinet and provide all the assistance in fulfilling the duties, responsibilities and functions of the cabinet. The secretariat assists in decision making in government by ensuring interministerial coordination, achieving consensus through the instrumentality of the standing or ad hoc committees of secretaries. Consensus, like I told you, agreement. How to ensure that Ministry of Defense will agree with Ministry of Home Affairs or Ministry of Environment. Call all the secretaries, sit together, discuss it out, sort it out, finish it off. So you get it done through the standing or ad hoc committees of secretaries. Management of major crisis situations in the country and coordinating activities of various ministries in such a situation is also one of the functions of the Cabinet Secretariat. So any major disaster occurs, anything major, big problems are there, that also generally where it is discussed, that is discussed within the cabinet. Clear, people? Prime Minister's office. So we don't have much to discuss on Cabinet Secretariat. In the news also, you will hardly find any details or data coming with regard to Cabinet Secretariat. The reason is very simple. It is generally because Prime Minister's office, whenever you have a single party rule, strong PM, Prime Minister's office will dominate Cabinet Secretariat. On the contrary, if you are having a coalition government and with that again you are having a weak PM, then Cabinet Secretariat will dominate that time. So now we are going to see Prime Minister's office. In parliamentary democracy, Prime Minister is the fulcrum of the power center. He is the epicenter around whom all the things happen. He is the center of power and responsibility. In fulfilling all the responsibilities, the Prime Minister needs institutional assistance, which is being provided by Prime Minister's office. PMO receives its authority from the Prime Minister, and he alone decides the functioning of the PMO. That is the reality. The Prime Minister's Secretariat was created in 1947, taking over the functions performed till then by the Secretary to the Governor General. From June 1977, it is known as Prime Minister's Office and is headed by the Secretary to the Prime Minister, who is now designated as the Principal Secretary to the Prime Minister. PMO enjoys the status of a department under the Government of India Allocation of Business Rules 1961. PMO is administratively headed by the Principal Secretary, who is assisted by Additional Secretary and Joint Secretaries. Below Joint Secretaries, there are directors who are assigned specific duties. So very recently, the former RBI Governor was appointed to Prime Minister's office as PS2. Means what? Principal Secretary 2. Second one. Getting the point? Primary one is the second one. Clear? Taking it further forward, the reason why he was appointed there, it is being said is Now, him being having this background in RBI, etc., if you have him as principal secretary there, he can give pure economic advices to the prime minister while taking any decision, because you have to factor in inflation and all of that. For that purpose, they have recruited him. Whose choice it is? Strictly prime minister's choice. Prime minister can literally handpick any officer and ask them, Aja beta, come to prime minister's office. Clear? There are various deputy secretaries and under secretaries that works for PMO. The personnel are generally drawn from the civil services and are also appointed for the waiting period. While most government servants serve at the pleasure of the President of India, the Principal Secretary and others working in the PMO serves at the pleasure of the Prime Minister. That is, it is entirely left to the Prime Minister. Prime Minister doesn't like, Prime Minister can tell you, go back to your home cadre. You go stay in your state only. Don't come here again. Otherwise, also, they can fix a tenure, 3 years, 5 years. So, anybody can be recruited here. That is the bottom line. It is left to the Prime Minister. And if it is a strong Prime Minister, single party, Prime Minister has complete authority there. Clear? Functions of the PMO. It is a staff agency mainly concerned with providing assistance to the PM in fulfilling its responsibilities as overall in charge of the government. Staff agency means what? Give advice. It initially had a low profile and was a non-constitutional, non-statutory body. The jurisdiction of the PMO extends over all such subjects and activities as are not specially allotted to any individual department. That means sky is the limit. They can literally interfere in anything and everything. Like I had told you, be it the recent Telangana tunnel collapse incident or the Silkyara tunnel collapse incident that took place in Uttarakhand, Prime Minister's office directly got involved there. That is the reason why all those rescue relief operations took place very fast. Coordinating between multiple agencies, asking them, what else do you want? Okay, you want the army. Okay, army is there. You want help from IIT. Okay, we are coordinating with them. They will get all the work done. Allocation of Business Rules 1961 provides the roles and functions of the PMO to provide secretarial assistance to the PM and acts as a think tank. It deals with all references which under the rules of business comes to Prime Minister, helps the Prime Minister in discharge of his overall responsibilities as CEO and as head of Niti Aayog. PM's Relief Fund and PM's National Defence Fund are managed by PM, which are based on voluntary contribution. So everything that the PM does, that is, he is a CEO and head of Niti Aayog, that work also will take care Prime Minister's office, because PMO's basic purpose is what? Secretarial assistance to the Prime Minister, just like a secretary. They will provide whatever work, wherever Prime Minister has to be involved, all that work will be assisted. Secretarial assistance will be provided by the Prime Minister's office. To deal with public relations side of PM, which is related to intellectual forums and civil societies, acts an office to get feedback of administration by considering public grievances against malfunctioning of administrative system. Like I think I told you this earlier also. So one guy from Bangalore, he had made a small aircraft on the terrace of his building. And he was trying to get approval from DGCA to conduct trial runs. DGCA was literally delaying the approval to give him license to fly it and try it and all that. He directly put up one tweet to the Prime Minister's office. Within 2 weeks, approval came from DGCA. Getting the point here. That means sky is the limit. Prime Minister's office, wherever they feel things are going a little too slowly, little too tardily, they can get involved. Same thing had happened even with the Rafale's deal. Rafale's deal, everything was happening in a very slow pace. What happened? The defense minister, or rather, defense minister, under the IAS officers in defense ministry, the secretaries basically, they were taking their own sweet time and doing things. Prime Minister's office bypassed it, directly interacted with the French government, pushed the deal ahead. Getting the point here. To provide prime ministerial assistance in examination of cases submitted to him for orders under described rules, so it acts as settlement house to finalize decision concerning to administrative doubts. The functional span of PMO is very wide and comprehensive. The functions of the PMO can be categorized into 4 parts. Routine function, which is almost like our programmed decision making. To review and monitor particular activities of the ministries, what each minister is doing and not doing. PMO and the policy formulation of the ministries. Functions basically related with Paul promises. That is the interesting part here. Politically also, to a certain extent, PMO assists. Because they will tell him, sir, see, we have or your party had promised these things. So far, we have achieved this much. This is pending. They give an update. Routine functions. The filtering of a large number of cases submitted by various ministries and cabinet secretary for information, approval, and sanction of the PM. That is, whatever requires direct intervention from the Prime Minister, after filtering it out, PM, it reaches finally, crossing even the cabinet secretary, finally reaches the PM. Prime Minister would likely to use his office to review and monitor particular activities of some ministries, keep a tab on developments on certain fronts, and at times depute staff officers to undertake sensitive assignments. At present, this has become a matter of concern. Why? Why has it become a matter of concern? Because involving everywhere. Tunnel rescue operation, or getting involved with the performance of certain ministries, anywhere and everywhere, PMO is intervening these days. And nobody is questioning it or threatening it or anything. Why? Strong Prime Minister. That is the reason. Strong Prime Minister, when I say, it is not just about that individual there, but the position of the individual within the political party and the approval rating what the Prime Minister has in the public platform. Paul promises. The PMO has to undertake some functions which cannot be clearly defined and recognized. Such functions are basically related with the Paul promises. Prime Minister may entrust a special cell in his office to monitor, review, and assist the implementation of each issues which are promised during the Paul. Changing role of the PMO over the years. I know those were very static, like again almost similar to cabinet secretary. What is the logic here? We'll understand this better when we go through history once. Extra constitutional device has attained power and grown in stature over the years. The roles, powers, and functions of the PMO heavily depends on the personality and style of the incumbent PM, the political scenario of the country, and challenges before the government decides the roles of the PMO. So, if we were to see the history here, we can clearly see Pandit Nehru. Nehru was firm believer of the parliamentary practices but wanted a strong PMO, but this was resisted by the then cabinet ministers. It is a cabinet secretariat which got importance under Nehru, and Prime Minister Secretariat was placed subordinate to cabinet secretariat. Nehru's dependence on PMS was less. Why? Was Nehru a weak Prime Minister? Not at all. But the fact of the matter is that Nehru had other strong personalities in the cabinet. Sardar Vallabhbhai Patel, best example. Getting the point here. So what happened? Cabinet Secretariat had most important position that time compared to the Prime Minister's Secretariat. And dependence of Nehru on PMS was very less. He depended more on the Cabinet Secretariat for taking his decisions. Taking it further forward, Lal Bahadur Shastri period saw steep rise in the role of PMS. Mr. Shastri's limited knowledge in international economic and scientific matters saw the PMS becoming powerful. Mr. Shastri, who suffered a mild heart attack, needed rest and therefore required assistance in managing the government's affairs. L.K. Jha was the secretary to the PM, and the personality of Jha was very dynamic and forceful to the extent he demanded that he be called the secretary to the PMS and not the PPS. That is, he did not like the whole term. That is, L.K. Jha did not like the whole term of principal private secretary. So instead he said, call me secretary to the Prime Minister's Secretariat. Call me that. And because the health-wise Shastri Saab was weak, Like he was unable to take a lot of decisions and very limited knowledge he had when it came to international economic affairs, etc. L.K. Jha took up central role there. So Shastri ji, rather than trusting his cabinet, he trusted whom? He trusted the IAS officer who was present in Prime Minister Secretariat, PMS. The then political condition in the country also helped in gaining power to the PMS. Jha influenced the economic policies and international affairs related policies. This also marked the beginning of the reduction in power of the cabinet secretariat. That means Shastri actually created that trend in the sense that when you don't trust your ministers, they all won election, you gave them portfolio, okay. But you feel somewhere decisions, whatever they are suggesting, whatever ideas they are giving are not correct. You want to take some independent decisions as the Prime Minister. You need a secretariat. So automatically Shastri started depending on the PMS a lot. The untimely death of Mr. Shastri, however, nipped this new experiment. The strength of the PM Secretariat increased from 116 in 1948-49 to 235 in 1965-66. That is, at the time of Shastri's death, strength has increased a lot. Clearly shows that he depended a lot on PMS. Jha also worked with Mrs. Indira Gandhi and even accompanied the PM during official tours. The role of Prime Minister Secretariat reached to zenith during Mrs. Gandhi's tenure. The staff strength was 242 in 1976-77. So you can clearly see again the number has increased. Indira Gandhi, again, no doubt why it increased again, because Indira Gandhi's biggest opposition, like I've already told you, was from her own party. Opposition that time also was not so strong. National level, union level I'm talking about, was not so strong. Biggest opposition was from her own party. So in such a scenario, PM Indira Gandhi's arch political rivals were from her own cabinet. So she did not trust whom? The cabinet or the council of ministers. So automatically she ended up depending very less on the cabinet secretariat and her dependence on Prime Minister's secretariat increased. This necessitated to depend on professionals for frank and professional advice, not hampered by parochial politics. L.K. Jha played a very crucial role in the decision makings of the Indira Gandhi government. PM Secretariat became the real decision making center and almost worked as the government of India. Later, P.N. Haskar, an IFS officer, was appointed as the principal secretary and same tradition continued. Haskar organized the work of the PMO and raised its caliber and potential for assistance and advice. PMS started functioning as a think tank, policy planner, political strategist, and a hub for coordinating the activities of the government. He too was confident of the PM. Confident means Prime Minister used to tell all the discussions, whatever she wanted to confide, secrets, everything to that IFS officer, Haskar, just like Jha. Advised the PM on all political and party matters to Indira Gandhi, including the 10-point agenda. Haskar proved to be one of the most successful secretaries of the PMO. Haskar was eventually given the title Principal Secretary to the PM. Dhar succeeded Haskar and the designation reverted to Secretary to the PM. PM's Secretariat continued to grow in stature. That means the foundation stone laid by L.K. Jha was carried forward by Haskar and later by Dhar. And PMO kept on growing from, or PMS kept on growing from strength to strength. Clear? During emergency, the role played by the PMS tarnished the image of the institution. Janata Party regime of 1977-79, efforts were made to reduce its excessive importance. The number of personnel was reduced from 229 to 203. And it was designated as the PMO, Prime Minister's Office, from Janata Party. Because simple it is. Janata Party, let me tell you, when they came into power, they only knew one thing. Whatever Indira Gandhi did, we will do its opposite. So Indira Gandhi depended more on Prime Minister's Secretariat, then we are not going to depend, we will depend only on the Cabinet Secretary. Oh, so one side you are having Secretary, then one more Secretary on this side. Why? Cabinet, will keep it as Cabinet Secretary. PMS, we will change the name and convert it to what? Prime Minister's Office. V. Shankar was appointed as the Principal Secretary to the PM. PMO was divested of some of its policy-making units like the Ministry of Information and Broadcasting, Research and Analysis Wing, and the Foreign Investment Promotion Board. During the tenure of Chaudhary Charan Singh, both the PMO and the PM had a low profile. During Indira 2.0, PC Alexander became the Principal Secretary to the PMO. That means 1977-79 till 19, that last part, just before Indira Gandhi came into power, PMO's entire thing got reduced. Later, in the second stint, when she became the Prime Minister again, Indira Gandhi, from 1980 to 84, once again PMO grew in strength. The role of PMO again took center stage. PMO assisted the PM in fulfilling her parliamentary responsibilities. PC Alexander was very much a part of all foreign visits and played a very important role in the foreign policy. PMO became more professional and tried to avoid the dangers of over-centralization. During Rajiv Gandhi's tenure, the office of the PMO grew further in importance, where the staff strength increased to 388. VP Singh, who never had a good opinion about the PMO, soon started liking the office after he became the Prime Minister. That is the point now. Later Prime Ministers who came into power, even they started what? Even they started enjoying that office because they found it to be very professional. No politics involved. Nobody is, because everybody are answerable only to the Prime Minister, unlike the Cabinet Secretary. In a Cabinet Secretariat, you have a committee of secretaries. Each secretary belongs to each ministry. So they will show more allegiance towards their minister. When they discuss anything, say anything. Politics gets involved there a lot. Not PMO. So it became a very professional body giving pure, objective, rational decisions. During PV Narasimha Rao, the PMO provided all the political support required to the PM, and Mr. Rao depended heavily on PMO under A.S. Verma during this politically unstable period. Prime Minister's office played a crucial role in reshaping economic policies during this phase. The Foreign Investment and Promotion Board was kept directly under the Principal Secretary to the Prime Minister. If you remember, during the Janata Party, Foreign Investment Promotion Board was removed from PMO. Brought back again. The PM was in charge of many ministries and departments. During the tenure of Deve Gowda and I.K. Gujral, PMO was active but not that strong as the governments were a result of coalition. So like I told you, wherever you have a coalition government, PMO will become weak. This, however, changed when Vajpayee became the Prime Minister. PMO under Brajesh Mishra became a powerful institution. The faith of the PM on Mr. Mishra was absolute, and it led to the creation of the post of National Security Advisor. The staff strength increased to 400. Vajpayee's time period. Later, Manmohan Singh. Obviously, coalition government. Politically, Manmohan Singh, we can definitely say he was a lot weaker. PMO under Sanjay Baru during the tenure of PM, Dr. Manmohan Singh once again reduced in importance because of the compulsions of coalition politics. National Advisory Council decided on policy matters, and this overshadowed the working of the PMO. You may be wondering, sir, what is National Advisory Council? We have never heard of such a thing even in the paper. Prime Minister was Manmohan Singh. National Advisory Council was actually headed by Sonia Gandhi, where Manmohan Singh used to sit like any ordinary member. And in that advisory council, decisions were taken with regard to what should be the government's policy. So in the National Advisory Council, there was an IAS officer to assist Sonia Gandhi. Getting the point here. So what happened finally? Sanjay Baru, etc., they had to wait for what is the decision from Advisory Council. Not constitutional, not statutory. Whatever decisions were taken there, that has to be followed up by Prime Minister's office. So Prime Minister's office did not have that independence what it had earlier. They had to abide by guidelines given by the National Advisory Council. Presence of eminent staff like Pranab Mukherjee and A.K. Antony in the cabinet further undermined the office of the PMO. True, A.K. Antony, Pranab Mukherjee, Jairam Ramesh, P. Chidambaram, Kapil Sibal, all these powerful people are there in the cabinet means automatically Prime Minister's office will reduce in its importance. The PS, Principal Secretary to the PMO, T.K. Nair, did not have a strong demeanor unlike his predecessors. Nair depended extensively on Pulok Chatterjee, who was a joint secretary. This was the guy who was answering to the National Advisory Council. The Cabinet Secretariat, National Advisory Council, National Security Agency, Planning Commission emerged as strong contenders in the policy and advisory space. This further corroded the decision-making abilities of the PMO. That is parallel decision-making bodies. PMO one side, Cabinet Secretariat another side, National Advisory Council this side. Then you have a Planning Commission. What is the job of all of them? Decide policies of the government. But who is finally calling the shots? Because Congress President was Sonia Gandhi and she was heading the National Advisory Council, it goes without saying that National Advisory Council did dominate the Planning Commission, the PMO, as well as the Cabinet Secretariat. Narendra Modi, who became India's Prime Minister in 2014, brought in a style of functioning very much similar to his stint as the Chief Minister of Gujarat. Modi's PMO is the most dominant PMO of recent times because Modi is known for that. When he was the Chief Minister of Gujarat also, he used to interact and take advices maximum from bureaucrats rather than from his own party colleagues. He selected the officials based on their experience, expertise and performance, like how he chose P.K. Mishra as the Principal Secretary and Ajit Doval as the National Security Advisor. Modi, unlike his predecessors, has not vested all powers in a single individual. That is the principal thing that he did. That is, Principal Secretary. With regard to other policy matters, it is P.K. Mishra. When it comes to security-related matters, it is Ajit Doval. Foreign affairs also used to be a strong topic under PMO. But for that also, what did he do? External Affairs Minister Jaishankar. So he ensured that each specialist is handling each area. So the Principal Secretary did not do all the tasks like maybe during Indira Gandhi's tenure or Vajpayee's tenure or even Narasimha Rao's tenure or even Shastri's tenure. Here it was like, okay, 5-6 specialists are there. Each one of you are specialized in a particular job. You will handle that particular portfolio. Like that, he divided the work. Thus, he brought in a system of checks and balances, brought in division of work and responsibility, and also created alternate sources for advice. This clearly shows that PMO is a reflection of the work culture and personality of the PM. So he kept everything separate out. So never you will hear P.K. Mishra complaining about Ajit Doval or Ajit Doval complaining about P.K. Mishra. Why? Both are handling two different portfolios. This is not going to mix with this. This is not going to get mixed with that. Prime Minister Narendra Modi has set up a monitoring group under the chairmanship of Union Minister of Agriculture, Farmers Welfare and Rural Development, Shivraj Singh Chauhan, to review implementation of schemes announced by the Prime Minister and in the Union budget, subordinate legislation and other infrastructure projects. With his involvement in both day-to-day administration and global affairs, it is believed that the Prime Minister has been concerned about the time lag in the implementation of government schemes and has often made his apprehensions known in closed-door meetings with his secretaries and top PMO officials. That is, he is very concerned with the fact that I am going on telling this scheme is there, that scheme is there. How much has it been implemented at the grassroots level? So there is a limit, right? These are ultimately officers who are sitting in where? Sitting in Delhi. How will they know what extent things are working fine? So what did he do? He did not stop there. He created a monitoring group. under the chairmanship of Union Minister of Agriculture, Farmers Welfare and Rural Development, Shivraj Singh Chauhan. We have tried to develop the PMO as a catalytic agent which becomes a source of new energy and inspiration, the Prime Minister said. Like I told you, all these he's constantly making that body in such a way that it becomes very efficient in running. Monitoring. Most importantly, review. Classic case of systems theory. Because according to the feedback received from the environment, he is constantly evolving the nature of working of the Prime Minister's office as well as its structure. Okay, people. So with that, we come to an end of today's session. So I hope the difference is clear to you. So PMO and Cabinet Secretariat, you can get a question. Again, it is on a comparative basis only. So that brief history what I gave you there, please keep that in mind. How, depending on the type of individual that the Prime Minister is, how Prime Minister's office will evolve. And depending upon whether the Prime Minister is weak or it is the coalition government or you have other strong ministers in the cabinet, how Cabinet Secretariat will dominate Prime Minister's office. These are the only two things that you need to know. Clear, people? Any further queries or concerns are there, please send it into the Telegram channel. All right. Let's call it a day.